All right, so yet another interesting development in Diddy's case. The judge is not going to allow the government to use the notes that had been previously taken from Diddy's sale. Those notes cannot be used at this upcoming bail hearing. That's a pretty big deal, and we're going to get into the details about that. But how we got here was the defense had requested a hearing. They demanded a hearing, basically, in order to get to the bottom of how the government got these notes, the context and how they got these notes and how they ended up in the prosecutor's hands, right? And this was such a big deal because the defense argued that these notes were subject to attorney-client privilege. And so attorney-client privilege is basically what protects communications between an attorney and their client from disclosure to third parties. And, for me as a criminal defense attorney, I've been doing this a long time. I've been a lawyer for 15 years. And so I have thousands of details of client conversations that will go with me to the grave. We're talking about attempted murders, robberies, drug sales, you name it. Again, no judgment, right? No judgment, but this is attorney-client privilege and it's really important, right? We're going to get into some of the reasons why it's really important, but to just kind of define it for you in case you're not aware what attorney-client privilege is their communications, and there are three elements that need to be met in order for something to be considered subject to attorney-client privilege. First of all, there has to be a professional relationship. So there actually has to be an attorney-client relationship. The second element is that the communications were intended to be confidential, right? So if somebody messages me on, tags me in a comment either on YouTube or on Facebook or on Instagram, and that's on a public forum, then that can't be subject to attorney-client privilege because it's not meant to be confidential. And the third element is it's basically for the purpose of either seeking or providing legal advice. So if those three elements are met, then the communication is subject to attorney-client privilege. So if you're asking yourself, what is the big deal about attorney-client privilege? Well, it is a major deal. One of the biggest issues is it fosters or encourages open and honest communication from the client to the attorney, right? If a person understands that the lawyer can't go and turn around and tell their brother or their mother or their best friend, or, the lawyer can't be compelled in court, the judge can't order an attorney to break attorney-client privilege, the attorney isn't going to turn around and tell the DA confidential information. This is a really big deal. For me personally, I'm pretty good with establishing rapport with people in a short amount of time, and I don't really have a problem with getting people to open up. In fact, ever since I was a kid, people have just, felt comfortable telling me secrets that they wouldn't tell anybody else. I can't tell you how many times I've heard early on in a conversation, I can't believe I'm telling you this, but blah, 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 right? But even with that, even with being able to establish a rapport with people, sometimes I have to remind them you can fully tell the truth and be open and honest, because I can't go and turn around and tell anybody else. This is subject to attorney-client privilege. And then, you see the weight lifted off the shoulders, you see the sigh of relief, and then they can speak openly and honestly. And so if a lawyer could disclose those things, then it would discourage that open and honest communication. And on top of that, we also have, Fifth Amendment rights, protections against self-incrimination. We have the Sixth Amendment right to counsel. And then there's also just fundamental fairness and justice that, protects us from government intrusion on attorney-client privilege. And so that's why this whole thing about these notes is such a big deal. The defense was arguing that these notes, they had to do with defense strategy and defense witnesses, and those are definitely going to be, buzzwords that bring us in the realm of attorney-client privilege. Because if you're talking about our defense strategy, okay, this is how we're going to defend our case. Or if Puff had ideas on, okay, this is, these are notes on what I want to bring to my attorney's attention next time we talk, and it's concerning strategy, then that's definitely going to be in the realm of attorney-client privilege communication. Again, Judge Subramanian had directed the government, hey, you need to get rid of those notes. But the interesting thing is he has not yet ruled on whether these notes in part or wholly are subject to attorney-client privilege. So that's yet to be determined. But in the meantime, he's saying, government, I want you to get rid of this stuff because until I've ruled on this, I don't want you looking at this anymore. That's a fair position to take. Both sides are going to have to write legal briefs on their arguments that for the defense that these notes are subject to attorney-client privilege, and on the prosecution that they're not, and why. And this brings up an interesting issue because I think sometimes people believe lawyers and even judges, we're just walking encyclopedias and we know the law like the back of our hand on these nitty gritty details of legal principles. We understand general legal principles, but when it comes to the specific details of whether attorney-client privilege is going to apply to each and every one of these notes, what has to happen is legal authority needs to be cited and arguments made, and then the judge can take both of those arguments and those legal citations and ultimately determine for himself whether these notes really are subject to attorney-client privilege, and then given if they are, then what he'll do from there. So that has not yet been decided. But what we do know is that the prosecution is basically expected to double down on what they argued before and basically assert that these notes were not subject to attorney-client privilege, right? So they've already made their position clear because they said that, hey, these notes didn't have anything to actually do with legal issues. Remember, we talked before about how the notes have to be for the purpose of either providing legal advice or accepting legal advice. And so they were saying that, there were notes about music releases and family matters and just other, business type talks. Obviously Puff had his hand in a bunch of different, business ventures. And so if these didn't have anything to do with legal issues or for the purpose of providing or receiving legal advice, then they wouldn't actually be subject to attorney-client privilege, and they wouldn't be that big of a deal as the defense is making it. The prosecutor's other argument that these notes are not subject to attorney-client privilege is that they had to do with the paying off of witnesses. So remember, the government's been arguing that Puff has been engaged in obstruction, witness tampering. They're saying that some of these notes had to do with the paying off of witnesses and trying to get people or plans to get people to dig up dirt on potential witnesses. So there's something called the crime fraud exception. And if a client is trying to ask their attorney for advice on how to avoid detection by law enforcement in order to commit a future crime, attorney-client privilege is not going to apply to those communications, and they would not be considered privileged. And so that's what the government's arguing in this situation, that the crime fraud exception is going to apply to these communications. But regardless of how the judge ultimately rules in terms of attorney-client privilege as it relates to these notes, the notes are not going to be considered at the bail hearing. So that's a major blow to the government's case in terms of their arguments that Puff should remain detained, because they really cited at great length these notes in support of their argument opposing bail. So another separate but related issue that came up regarding these notes has to do with the defense's arguments as to why these notes were privileged. The defense, in support of their arguments, was mentioning that Puff had these legal pads that said legal on them. And there was a folder that also had legal on it. That's what put people on notice that these were legal documents and subject to attorney-client privilege. But the issue that came up was at the hearing on November 19th, the defense showed the judge two of the legal pads, and they had legal on the binding. So if you have this isn't a legal pad, but let's just say, they presented it and it said legal here, right? And so they would say that as proof, these are legal pads and have the contents that would be subject to attorney-client privilege. It's like, Your Honor, it says legal on here. Well, the issue was apparently the photos that the court had in its file. So remember, the investigators that did the sweep of Puff's cell, they didn't actually take the contents. They took pictures of these things. And so on the pads that were in the photos in the court's file, they didn't say legal on there. So this raises an interesting issue of, wait, how is it that you're coming into court and now it says legal, but the pictures I have, they don't say legal on it. So the court in its ruling and its direction didn't exactly say, and they wouldn't say, you're lying, but they're asking for some clarification. I want you to explain, what's the deal? Like, why did the legal pads that you brought into court and referenced as proof that these are subject to attorney-client privilege, why did they see legal on it? And these pictures that I have that were taken back in October, they don't have legal on it. So if you're making some sort of misrepresentation, listen, the attorneys have a duty of candor to the court, and you're not supposed to make representations to the court that you know to be false. So, again, throwing accusations out there that an attorney is being dishonest or lying to the court, that's a big deal. And I'm certainly not going to, do that with no proof. But it seems like that's what the judge is getting at, and that is to be addressed at tomorrow's hearing. One of the other things that he asks is, well, you didn't put that in your papers, right? So there was an additional filing that was submitted just hours before that November 19th hearing, and there wasn't reference apparently made to the writing of legal on the binding in these notepads. So he's like, well, I want to know, well, why didn't you reference it in what you submitted to me just hours before the hearing? So it just raises some suspicion. So we'll find out tomorrow what the defense presents in order to explain the discrepancies. So this bail hearing is tomorrow, and even with these notes not being presented as part of the government's argument, Puff still has a crazy uphill battle in order to try and get out of custody, but we'll see if they pull it off. Let me know in the comments below how you see this thing playing out. If you got something out of this video, please show me some love, hit the like button, make sure you subscribe to the channel and turn on those notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.